Well, all right. So thank you everyone for joining us. My name is Vadim Cherkasov. I'm an intellectual property attorney at McCarter & English out in Philadelphia. First, before we get started, thank you to Toto and NextFab for organizing the webinar. Hopefully we'll cover some good information. I know, Nicole, you're familiar with NextFab, but Igor, at least for your purposes, it's an organization here in Philadelphia and Wilmington. I became familiar with them when I first moved to the Philadelphia area about 8 years ago, and they really have a fantastic group of individuals who can help you with prototyping from the engineering side and then finance as well. And Toto runs the accelerator at NextFab. So thank you, Toto, for organizing the webinar. I appreciate it. And as the slides say, today we'll be talking about intellectual property considerations. The goal is to kind of go over some of the different types of intellectual property that may be available to you if you're interested in obtaining protection. Some of the issues you should think about as you progress, from the early stage of starting your business and on beyond that as the business grows. And then we'll have some breaks in between for questions if anyone has any, and then we'll have some question Q&A session at the end as well. All right, so just a quick background about myself. I was a mechanical engineer for a number of years. I worked in the industry before becoming an intellectual property attorney. So I had a chance to work from the engineering perspective as well. And now as an attorney, I work with a lot of engineers who develop new ideas and seek protection for them. I've been in McCarter for over 10 years at this point. And like I said, I'm part of the IP group. It is the biggest group of the firm, but we also have other practice groups as well. And it helps to work hand in hand with them to develop the IP portfolio, but also helping the corporate or employment side as the business grows. So it's a nice way to kind of handle all the different issues for businesses as they go from that early stage to actually commercializing and then expanding. NextFab, again, collaboration since 2016, and typically what that involves is office hours. So I make myself available to speak with the members if they have any questions. We'll be doing that today as well, but you can always reach out to me via email if you'd like to set up a call, and we can always just chat for a little bit and see what IP questions you may have. But if you do have any questions today, please, when we have the Q&A session, let us know and we'll be happy to answer them. All right, so why consider IP protection in the first place, right? Why is intellectual property so important? It's very easy when you're first starting your business. If you come up with an idea, if you have some kind of product, it's easy to jump ahead and start focusing on the market, trying to actually finalize the design and commercialize something. And at that point of the company, it might be tough with finances, so you really are trying to focus the finances in the direction of marketing and commercialization. But from an intellectual property perspective, particularly from patents, there are a lot of time-sensitive issues that need to be considered. So it's important to think of the IP perspective at that early stage. And even if it's difficult from a financial perspective, consider whether patent protection specifically is something that is of interest or is an option, because you may miss a window of opportunity to obtain that protection. The other focus is on the potential growth of the business, right? So when you're just getting started, let's say you're working just out of the Philadelphia area and you're just focused on the local market, you really need to think beyond that, right? Where do you want the business to go in the next year, in the next 3 years, 10 years? And think about what kind of expansion you would like to have, and what expansion there would be in the business, because that will affect some of the steps you should be taking early on as well. Another consideration is from an investor perspective, right? The goals that you have for the business may not necessarily be the same kind of goals that a potential investor in the future will have. So you need to kind of keep all of that in mind, kind of balance it out, and and see what the potential correct steps should be early on to establish a good foundation, so that you have a clear path moving forward. The 4 types of IP that we'll be talking about today: patents, trademarks, copyrights, and trade secrets. So if you have developed some kind of new product, something that's really innovative, you may be eligible for patent protection. Trademarks, if you have a logo or business name, if you're trying to market some kind of product with a whether it's an illustration for the logo or an actual name for the product, you should potentially pursue trademark protection. Copyrights protect any kind of works of authorship. So we're talking about photographs, podcasts, music. And then finally, trade secrets it's anything that's secret and proprietary, more internal information for a company. So we'll go through in more detail during the presentation about each one of these. But these are the 4 types of IP that is available to you. All right, so patents will be the first one that we'll focus on, and you'll see that the majority of the slides will focus on the patent side, just because I think there are a lot more issues to deal with patents, and the majority of my practice focuses on patents as well, even though we do handle trademarks and copyrights. So for patents, I say it's a love-hate relationship, because it's really it's a balance, again, from a financial perspective of whether you should be pursuing patent protection or not. The patent process may at some point become expensive. It depends. It's a case-by-case basis, but depending on how long the examination progresses, the patent process may become expensive. But if you have an innovative product and this is what your business is really focused on, then obtaining a patent may be the only way to actually protect that innovation and ensure that you have at least some kind of advantage when you're entering the marketplace. So it's important, again, to consider the balance between the cost associated with pursuing a patent and what the opportunities may be if you get a patent down the road. And then in terms of startup success, when investors are looking at a company, when you're going through funding rounds, depending on what level you're at, a lot of the time investors are looking at the IP portfolio, specifically patents, if you have some kind of patentable subject matter involved. And if they see that you have taken some steps to actually protect yourself with patent protection, then it gives them some more comfort in funding the business. It shows them that you've taken some necessary steps, you're serious about the process, and again, you kind of have a chunk of the market share before the competitors will be able to move in later on. So it provides a little bit more stability and generally correlates with success for startups. I mentioned before that for an early business, it can be difficult to kind of make that decision about pursuing patent protection. I've participated in a lot of innovation competitions. Generally, but I've seen some of them at the university level, and what normally happens is you present a panel of judges, and the first or second question is always about patent protection if someone has some kind of innovative product. And surprisingly, I would say about 50% of the time, if the individuals are asked about pursuing patent protection, the answer is usually no, they have not. They have not pursued it. They may be considering it, but they have not done so. And as we'll discuss today through some of these slides, because of the time-sensitive nature of patent filings, it's important to consider that before you enter these competitions, that you have these public disclosures. So when you do get a patent, it gives you the right to exclude others from using the invention. You do have to consider that it's a 2-step process. So once you go through examination, if someone starts calling your actual product, then you should take some steps to actually enforce those rights. So one half of the process is actually obtaining the patent. The second part of the process is actually enforcing those rights if someone is infringing on your rights. So keep in mind that it's there's a second part to this. if someone does begin to copy what you're doing. In terms of the patent process, there are four types of applications that we can pursue. A provisional patent application is a placeholder really for 1 year. It never on its own actually issues as a patent, but it's used if you're going outside of your inner circle to discuss the product, the idea that you're working on. So if you are unable to discuss the idea without using a non-disclosure agreement, for example, then a provisional patent application would be a good way to go, just to make sure that you have some form of protection before entering into these conversations. The utility patent application, it can claim priority to the provisional and then eventually goes through examination and can issue as a patent. The design application would be used for protecting the aesthetic look and feel of a product, and we'll have an example on the next slide. And then if you are interested in foreign protection, then one of the options is this PCT application. Then you need to, when you think about the IP or the patent options available to you, you need to kind of figure out what works best for you in your scenario. Is it, should you go straight to the provisional, or should you go to the utility design? And you have to keep those options open, but the provisional does keep the door open for pursuing protection in the US as well as internationally. So it's typically the way to go from a startup perspective who's still developing the product that they will eventually commercialize. All right, this is just a quick example of the difference between the utility and design application. The utility application with drawings at the top here, it has a full set of drawings that show all the details of the invention, a detailed description that talks about everything that is in the drawings, and then a full claim set at the end that actually defines the scope of protection that you would obtain for that patent. So the focus here is really on the claim set from the utility perspective, and when you're drafting the application, when you're having someone draft the application, great care needs to be taken for the claims, the way they're drafted, to make sure that the scope of protection is not too narrow. Right? The broader the scope of the claims, the more protection you have, the more valuable the patent it would be in the end. The design application, in contrast, is the drawing on the bottom, and the focus there is really on the drawings because the drawings define the scope of protection. So an example here, Tesla filed for a design application for the door of their vehicle, and so the door itself is in solid lines, everything else is in dashed lines for context. So when you're preparing the design application, you need to be careful about how the drawings are prepared, right? Rather than the claim set and the utility, the design drawings need to be prepared carefully to make sure they show everything, but you have the proper designation so that you're not limiting yourself. For example, the Tesla drawing here, it's just a car door being protected, but if everything was shown in solid lines, then you'd be going for a much narrower scope of protection because you'd be basically claiming the full vehicle. So when you have someone prepare these applications, you have to be careful about exactly how they're prepared and what you're claiming. So let's say you have an invention, right? What are the steps that you should take to see if you can file for a patent, if you can start commercializing it? One of the options to see if something's patentable is doing a patentability search. And this is something that you could potentially do on your own using Google Patents. We work with companies that do these searches for us, but the main question you're asking is, has someone else created a similar invention? And one of the mistakes that I see happen all the time is that someone will do a quick patent search and they'll say, no one else has done this, so I'm kind of free and clear to pursue a patent on it. But in reality, when you're doing this patentability review, you should be looking not just at patent literature, but really anything that's in the public domain. So we're looking at anything in blogs and videos and anything that's already being sold online. So it does not necessarily need to be a patented product, It just has to be something that's in the public domain already. In contrast, the freedom to operate search is where you are planning on selling something, and the question is there an issued patent out there with claims that have scope broad enough to encompass the product that I'm selling? So would I be infringing on someone else's patent that's out there? The review here for the FTO is focused on the claims, not the full application, but really just the claims. And it can be difficult to understand exactly what the scope of the claims may be. But for both of these, is it absolutely necessary to do a patentability search or an FTO search? The answer is no. We have plenty of clients who move forward with a patent application or move forward with commercializing a product without getting these searches done. But it can save you a lot of money down the road. For example, from the patentability standpoint, if you find something that's directly on point to what you're doing, then you would realize early on there's no need to file an application, go through examination, and spend the time and money on an application there. And then from the freedom to operate perspective, you could come across at an early stage of development still, you could come across a patent that could be problematic, and you still have an opportunity to redesign what you're doing so that you would not potentially not infringe on someone else's patent. And we actually had that recently with one of our clients who was actually already at the manufacturing stage and just a couple of months away from starting to sell their product. And we did this FTO analysis and realized that they would be infringing on a couple of patents of a competitor. And so they went back to the drawing board, had to redesign, and we're doing another FTO right now just to make sure that there are no problems with the redesign. But it can be an expensive venture to have these changes done along the way, but it saves you a lot of headache down the road if you potentially infringe and have to go through litigation. All right, so I mentioned previously, right, that you need to be thinking about the future of the business and where the business could go in the long run, not where it is now. And one of the main topics, one of the biggest issues for patents and why they're so time sensitive is related to public disclosures. So in the United States, if you publicly disclose what you're working on, you still have a 1-year grace period to pursue patent protection. So you're still able to file for a provisional, utility, design, one of those options. Unfortunately, many of the foreign jurisdictions do not have that 1-year grace period. And so if you had a public disclosure, let's say Elon Musk decided to post some new innovations about their vehicles on YouTube, that would be a public disclosure, and they would not be able to pursue patent protection internationally. So what do you do in that situation if you had a public disclosure, for example? Well, the goal would be to file a provisional as soon as possible to at least maintain those rights that you have in the U.S. But ideally, before you have a public disclosure, before you have some kind of posts on social media, for example, you would actually file for a provisional application. And then in some instances, if it's feasible, you use non-disclosure agreements to try to limit exactly what a public disclosure would be. So you try to make it more confidential in a way. Just as a quick example, I spoke with someone at NextFab actually who had developed an interesting product, something very simple but effective, and we spoke for probably 30 minutes. It seemed like we were headed in the direction of filing a patent application, and then the individual told me that they had actually posted something on Instagram about their product years ago, and so that right away it was the automatic bar for pursuing patent protection. So it's important to think ahead and think. You may only be focused on the U.S. right now, but again, if the business grows, potentially there could be interest in international protection as well. So ideally, you file at least a provisional, then have these public disclosures, and then make a decision a year later about exactly where you want to file for patent protection. One second. Another topic from the patent perspective is inventorship, right? So as the business grows, you may have started the business on your own and just have 1 or 2 individuals initially, But as the business grows and you have a team of individuals collaborating together, it may be difficult to tell exactly who should be listed as an inventor on the patent application. And while it seems like that is not a very serious topic, it's actually something that could potentially be used to invalidate a patent down the road if the inventorship is not proper. So it's an analysis that needs to take place pretty seriously, and it's not just a matter of who is actually just helping out, from a marketing perspective or from commercializing the product. You really need to think about who helped come up with what is being claimed in the application, and only those individuals should be listed as the inventors. So it's an analysis that needs to be done. That there are ways to correct the inventorship later on down the road if it comes up, and we've done that several times. It's just sometimes this gets lost in the mix, but it's always a good idea to make sure that you have the proper inventorship in place. And the final topic I have on patents is about the specification. So I say here that good specification is worth the investment. The reason I say that is the detailed description that you have in the body of the patent, that really lays the foundation, the support for what you have in the claims. So when you go through examination, and this could be 2-3 years down the road, as you go through examination, you may need to adjust the claims in some way in order to overcome the rejections that are being cited against you. And you need to have support in the specification to actually incorporate some of those changes into the claims. If the specification is not written well, if it's only a couple of pages, then you would have significant problems through examination, and you may not be able to obtain a patent down the road. So there have been a couple of instances like that where we either inherit a case, or someone decided to write a patent on their own, and they really focused just on one feature they thought was really unique, and the rest of the application is pretty minimal. And then we receive that case and we start working on the examination aspect, and it can make things very difficult because that one feature may not really be that novel down the road, but it might be a combination of features that should have been described in the application that can actually help get you to the overcome those thresholds to obtain a patent. So it's important to make sure that you, again, lay a good foundation when you do pursue patent protection. Make sure you have a strong specification. So on that note, that's all we have from the patent perspective. I'll take a short break to see if anyone has any questions. I know one of the questions that has come up in the past is, if you did not file for patent protection, for example, right, and you had a public disclosure, but you're still interested in protecting the product in some way, what are the options that you may have? So in that situation, obviously the product that was already publicly disclosed, if a year has passed, then you would potentially not be able to pursue patent protection there. But what you could do is have some additional improvements on the product, so some changes that have occurred since you've had the public disclosure, and then you would pursue patent protection on those improvements if they're novel enough on their own. So there are some possibilities to still pursue a patent protection if it is something that is of interest, but it would need to be something that's innovative enough that goes beyond what has been in the public domain basically after the disclosure.
Vadim, another question: are software or app-based ideas patentable?
Right, so that's a good question, right? So it's possible. A lot of the time, the conversations I have with inventors these days are that there's some kind of software aspect to an invention that they're working on, some kind of app that's involved, and it's possible that the app may be doing some kind of combination of elements that could be patentable, but it's the threshold for obtaining a software-based patent is usually much higher. It needs to be a significant improvement from the technical standpoint that improves some kind of operation, something that hasn't been done before. So simply using software or an app to speed up some kind of process just to gather data and to spit that data out to you, that on its own is not enough to obtain a patent. It really needs to go beyond that from a technical standpoint. So it's a lot of time it's a kind of case-by-case conversation that we have with inventors to figure out if something would indeed be patentable.
Got it. Thank you.
Anyone else have any questions? All right, well, we'll jump to trademarks then. So trademarks, they cover the source of the product or the services you're providing. So they identify exactly where the source is coming from. And this is developed over time. While you can pursue a registration early on, the brand name and kind of that market awareness, it is really something that's developed over time. So I have a couple of examples here, but if you see some of these marks, you right away know what products they would be associated with. And while you're working on that brand awareness, as you, let's say you come up with a product you'd like to commercialize, if you have a specific name for that product, you can start marking it in a certain way in any kind of marketing literature or really anything on your website, for example. If you use the brand name, even if you do not have a federal registration, it's always a good idea to mark the brand name with a TM, a little superscript TM, just to indicate that you're intending to use the mark as a trademark, and it puts others on notice about the potential use of a trademark. So even if you do not pursue federal registration, it at least has some effect to potentially prevent others from pursuing, from using that mark. And the other note here I have at the very bottom is about separating the generic term from the trademark or the brand name. That's also a good idea to do, just to show that there's a separation between what the generic name would be and then what the actual product is that you're working on. All right, so is registration necessary, right? Do you need to actually pursue federal protection for a trademark? In this regard, technically the answer is no. It's a little bit more flexible than the process from the patent perspective, just because it's not as time sensitive. So you do have some common law protection for the trademark. So if you're marking it as a TM and if you're putting others on notice that you're using it as a trademark, you do have some limited protection from common law, but it's generally limited to just a geographic area where you're actually selling the product. So if again, thinking about where the business could go in the future, let's say you're starting a business and you're only selling in the Philadelphia area, but in the future, as the business expands, you'd like to sell across Pennsylvania, or you'd like to sell across the Northeast or within the United States. You need to think about those issues when you're filing for the trade or using the trademark, really, to make a decision if federal registration is something that should be done on your end. And one of the things that can happen is, let's say you were only really focused on Pennsylvania as a market, but in the future you decide to sell nationwide. You may not be able to use that brand if if others in the meantime have started using it if you do not have a federal registration. So it's a good idea to file for federal registration, just to have that nationwide notice and protection, and it gives you that additional level of protection, some additional comfort in knowing that you can actually use the mark nationwide. So, and it's important to do your due diligence, make sure that you are actually using a brand that no one else, or not similar enough to what others are using. What you want to avoid is really getting that market awareness of a brand name that you're using, and then realize later on that someone else is actually using something pretty similar, something another mark that could be problematic, and then you have to rebrand, which obviously it's much harder to rebrand and then keep that that market awareness that you already had. And I've had a couple of instances like that. I was speaking with some startups that they had a trademark. It was not federally registered, but it was a brand name they were using, and then pretty close to commercialization, they realized that the brand they were using was almost in direct conflict with a competitor in the industry, and so they had to rebrand. And I think in that instance it was caught early enough, but you want to avoid those kind of issues as much as possible. So you can do a search on tests, for example, just to see what marks are out there and see if there is a clear path for what you would use. So important due diligence. And I didn't mention this before, but for design patent applications, you could potentially file for color schemes as well. So it's not just the aesthetic look and feel with the black and white lines. You could actually obtain protection from a design patent with some color schemes. We have a client that has a medical device that has certain colors involved, and they filed both the black and white and color drawings. But another option for protecting color association is for trademarks. So if you have a market association with a certain color scheme that you've been using, you could potentially pursue trademark protection as well. And I don't know, we have a small group here, but if anyone wants to participate, I have a couple of examples. And if you want to take a guess at what the companies are, I'll give a couple of minutes or a couple of seconds to see. Does anyone know what this color is associated with?
Tiffany?
That's right. That's good. So Tiffany, how about this one? John Deere, if anyone's familiar with them. This one, if you do any home improvement.
Home Depot.
There you go. And then this final one, it comes off very dark here, but it's like a dark brown color. It's UPS.
Probably UPS. Okay.
Yeah. So these companies obviously over the years have developed some kind of association with these colors, and you can imagine how valuable it is, for example, for Tiffany and company to actually have a trademark on that color, and they enforce their rights there. So from the trademark perspective, if you do have a trademark, you need to enforce your rights to prevent dilution, prevent losing the value in the brand. But there are a lot of different options for obtaining protection from a trademark perspective. So I'll take a quick break here, see if anyone has any trademark questions.
I do. This is Nicole. I was wondering, when you have a trademark, do you have to renew it every 5th and 6th year or 9th and 10th year?
Right, that's a good question, right? There is a requirement to file the certificate of use. And so part of the process for trademarks is that the U.S. Patent and Trademark Office does not want you to kind of keep a hold of a trademark, prevent others from using it if you're not actually using it yourself in commerce. So when you file for a trademark application, the typical process would be, if you're already using the mark in commerce, is you file the application, you file what's called a statement of use, and you submit specimens, just photographs of the product with the brand name to show that you're actually marking it. And there is I believe, like you said, I think it's the 3rd, 4th, and 5th year, maybe. I don't know the exact specifics there, but there are years where you need to submit that statement of use and show that you're showing continued use, and then you have to continue to submit those, I think, every 5 years in order to show that you're actually still using it in commerce in order to maintain those rights.
The irony with that is that I got that email today, so I just thought that had to be spam or something, or they were listening knowing that I had this class today, because I got the email today for that, and that's why I'm like, okay, well, is this spam or is this real? So
You do have
very
to be careful
interesting.
with spam, honestly, because the U.S. Patent and Trademark Office, a lot of the information is publicly available. You have to be careful about what notifications you receive. So you need to double check everything.
And
But
that's the reason why I'm asking you, because I get so much mail, and then at the bottom it'll look legit, and then at the bottom it's like, yeah, send me money, or it just doesn't seem official. So I started ignoring everything, and now need to know if I do need to pay attention to something. And now you're telling me that I actually do have an action item coming, because I thought what I got today was spam, but it probably wasn't, and it didn't ask for money.
yeah, I mean, I would recommend in those situations to just double check on the official trademark website to see what the deadline would be, and kind of figure out from that point, because there are you do have extensions available in those instances, so that you can potentially extend when that statement of use is submitted to the trademark office. But yeah, you have to be careful. Unfortunately, a lot of our clients get these spam notifications, and they always double check with us to make sure that it's something something official. So do double check and make sure that it is actually something that is due at this point.
Okay, thanks.
Any other questions?
Yeah, I have one. So let's say I've gone through the process of getting the trademark and everything is great, but then I figure out that somebody has a similar mark. So what should I do in a situation like that? How can I prevent them from using that mark?
Sure, that's a good question. So if you realize, and this is something that's related to copyrights as well, and really patents, really any form of IP, but if you see that you have a registration and someone is doing something similar, has a similar mark, the preferred route is non-litigious, right? You send a cease and desist letter. It should be in writing. It should be an official letter, something that you can keep track of to show that it was delivered. But the goal would be to send a cease and desist letter and try to open an avenue for discussion, because the other party may not be may not know that you actually have a registration. They may not realize that they're infringing potentially. And so it's good to put others on notice that way, at least from a legal perspective, just in case the conversation does not go in the right direction. But then you try to, in a non-litigious way, have that conversation, try to work things out and potentially get some kind of royalty payment from them. In the end, something like that, approaching it in a more kind of softer way than automatically saying that you would sue them for infringement, it could potentially result in some kind of growth or expansion for the business, and it could actually help you in the long run.
Got it. Thank you.
Mm-hmm. All right, we'll do a quick run through copyrights and then have a couple of additional topics to the end. So copyrights, any kind of work of authorship, again, as long as it's independently created, as long as you're not copying someone and you fixate it in some kind of way, then you have the rights to control how that information would be distributed out. So really any kind of artistic work, any kind of literary work would apply for copyrights. And this kind of repeating topic from trademarks is the main issue with copyrights is to make sure that you're putting others on notice that your work is indeed protected by copyright. So federal registration is not required, but it is nice to have a federal registration to have your copyright in some kind of central national database that others could access. But what you can do, and what's recommended, strongly recommended, is to make sure you're at least properly marking the work that you've created with the copyright symbol, the year, and then the name of the owner, to make sure that others are noticed about the copyright protection and the fact that you are indeed the owner, so they can reach out to you if there are any questions. I guess on the other hand, if you're actually looking for, let's say, images or music to use, incorporate in the work that you're doing, a lot of these search engines have advanced search features that allow you to figure out, is something freely available, or you need to license it out. So it's a good idea to use that kind of search feature just in case, and have a little bit more kind of comfort moving forward, just to make sure that you're not using something that's copyrighted and then run into problem down the road. And of course, the easiest solution is potentially to use a legitimate source, pay a small licensing fee, and then know that you have a clear path for using the work. We had a potential client who spoke to me, but he had published an entire book and then received a cease and desist letter saying that the photographs he had used throughout the book were copyrighted and that he didn't have the rights to use them. And so in the end, it just became too difficult of a process to overcome, and he ended up actually dropping the project because it just, even though he had already published, I think, a large number of the copies of the book, it ended up being financially not worth it for him to actually move forward with the project. So it's a good idea to check, again, do due diligence, make sure that you're using works that are not copyrighted, or at least you have taken the necessary steps from a licensing perspective to get the proper rights to use the images. One quick slide on trade secrets. It's anything that's internally proprietary. The best example is really the Coca-Cola formula, and this big secret around what exactly is the formula for Coca-Cola. The Google algorithm is another example. It's something that parts of it are known, but not the main kind of bulk of the algorithm. So what happens in those instances is rather than filing for a patent application, which potentially would be available, and only having 20 years of protection, what these companies have done is they've taken internal steps to maintain this internal process secret enough and within just the inner circle of individuals, and that on its own maintains it as a trade secret. So as long as you're not publicly disclosing it outside of that inner circle, then you can potentially maintain it as a trade secret indefinitely. So the Coca-Cola formula, I think, was developed around like 1891, and because they've maintained it as a trade secret, they continue having that protection. You're obviously not doing any kind of licensing from the formula itself, but you have the brand name to work off of. So there's some ways, alternatives to patents. Potentially trade secrets are an option, but it's not really an option for everyone. It's kind of case-by-case basis. All right, a couple of additional topics, then we'll go to the Q&A. So if you're just an individual who is making some products, again, for your small group of individuals around you, you're not really commercializing, then having the IP or the patent, let's say, in your name, it's not a problem. But if you're growing your business and you start commercializing, selling nationwide, let's say, right, it's a large network of individuals, it's a good idea from a liability perspective to form at least some kind of entity, like an LLC, assign the IP over to the LLC, and then basically have all those steps, all the commercialization go through the entity itself. And what that does for you is it provides this small barrier, at least, so that if something goes wrong with the product you're selling, if you sell something and it explodes and it hurts someone along the way, you at least have some kind of liability protection from a personal perspective. The company would still be liable potentially, but you yourself would not be. And then from an investor standpoint, having the IP in one place assigned to the entity is also a much cleaner look and much easier to control than if, let's say, you have 10 individuals working on it and each one owns that IP initially as the inventors. Let's say, at that point, it's much more difficult to control if people are moving around, if people are leaving the company. It's a good idea to have the IP assigned to just the LLC and have control from the LLC perspective. From the licensing aspect, there you really need to be focused on the clarity of the terms, make sure that you are taking the right steps and protecting yourself if you're entering into a licensing agreement. So exclusivity, right? It's are you going to make it an exclusive license for one company where only they can practice the specific IP, or do you want to leave the door open to potentially have others also license the technology from you? So the exclusivity is a big part of the process. And again, think ahead about where you want the business to go. Is it, are you okay with just giving it to one company and letting them run with it, or you want to leave the door open for others to do so as well? Geographic limitations, again, will the IP only be used in one state or nationwide? Both of those obviously affect the royalty percentages that can come up. And then the further development of the IP, if someone is licensing the technology from you, who will actually own any kind of IP rights and what's developed later on. So it's important to make sure you have clear terms and think ahead. Again, the main topic I think today is think ahead about where you want the business to go, and make sure you take the necessary steps to protect yourself along that way. The final topic I have here about hiring employees. So initially, I think the topic really applies even early on. If you're hiring others to do the work for you, if you're hiring engineers to create a prototype, for example, or help you further refine the product, you want to make sure that you have the right agreements in place, so that any kind of work for hire has the language there to really indicate who owns the intellectual property, and that there's an obligation of those workers to assign the IP over to you or to the LLC, to the company that's involved. And when you hire employees, you want to make sure you have that obligation to assign clause in their agreement. The main reason is that, again, people move around, right? You start out with 10 people collaborating together. A couple of those may move around, and what happens is, if we do not have an actual assignment from them for a patent, let's say, we can actually rely on that employment agreement and that obligation to assign clause instead of an assignment document. So it's important to have that there, because if you do not have the correct language, you can run into a lot of problems, right? A lot of conflicts that could come up in the future. And I've actually had conversations with people who are working with companies in China to manufacture, and they did not have an agreement in place. It was just emails back and forth, a few texts, and they don't have an agreement in place. And they run into problems, and there's nothing to rely on to potentially resolve those problems. And others who do product design for different companies, individuals, do work for hire work, but there's no agreement in place, and they have questions about who owns the IP to develop technology. So it creates a lot of unnecessary questions, a lot of problems that could come up, and it's easy through these agreements to just have a cleaner route to make sure that you don't have problems down the road. All right, I think I've spoken enough at this point about IP. Hopefully, some of the topics we've covered help to at least think about some of these issues as you develop a business, and would help you take some of the right steps to lay the proper foundation as you grow the business. So I'm happy to take additional questions if anyone has them, but you can always reach out to me via email as well, and we can set up a time to chat if you have more specific questions.
Hi, Vadim. I have a quick question. This is quite common in the software industry. When an employee starts in a company, full-time employee, there are sometimes rules that all the inventions that the employee makes outside of the company still belongs to the company, even if it's not directly related. Is there any recommendations how to handle this from an employee perspective?
Yeah, I mean, I think that definitely happens a lot. I agree with from the software perspective. I mean, really from any company, in the medical industry, it happens often as well, where the language does say that anything developed outside of the business is still owned by the company. And the reason for that is these companies expect that because you're spending their resources you're not developing the invention necessarily using their resources, but it may be on their time. If it's at least partially related to what you're doing or work, then they consider that to be part of part of your employment, and based on the employment agreement, they should own rights in it. If it's completely unrelated, if you come up with something that is completely different from what you're doing your work, then my recommendation would be to speak with the employer before you actually take any steps to protect the IP. I mean, you don't need to actually file for patent protection, but you potentially see if they would sign a non-disclosure agreement, and you would not need to disclose all the details, but it would be good to speak with someone at the legal department of your employer, and just to say, look, this is something I've developed on my own time. It's not related to what we have at work, and I'd like to pursue patent protection for it. And what the company can do in that instance is provide some kind of waiver, some kind of document saying that they had a discussion with you, and they agree that it's not an issue, and then you'll be able to pursue protection on your own. It's a good idea to take at least some of those steps, because again, the last thing you want is to file for a patent, let's say, start spending time, money on it, and then realize later, the company finds out about it and says, well, you developed this during your time with us, and it can complicate things. It becomes a gray area. So it's good to get these waivers. I know for me, a lot of individuals who work at universities, they have obtained those waivers if the university is not interested in moving forward with it. So even if the technology is directly on point to what you're doing from an employment perspective, if the company's not interested in that IP at all, then you may still be able to pursue it on your own. We had a client in the food fabrication business where someone had come up with, actually during the pandemic, for something with UV protection, masks with UV protection, and the company was not interested in moving forward with that technology, and so they actually gave the rights over to the individual, to the employee, to pursue on their own. So there are a lot of options that you could take, but it's always a good idea to speak with the legal department just to make sure you have that clear path forward. All right, thumbs up from you. Any other questions?
Yeah, just a quick one. So is there a package of documents that, in your opinion, every company should have so that they start on a solid foundation? And if there is, do you folks offer something like this at your firm?
So yeah, from an IP perspective, at least, there's no set of documents necessarily that we just go out right and give you. It's really a case-by-case discussion to figure out what is relevant, and that's what I do a lot of the time with these initial consultations or discussions, just to figure out, is there any intellectual property that's actually worth protecting. But we do have, from a corporate standpoint at least, we do have a group in our East Brunswick office that works with early stage startups, and they do have kind of package deals where they cap the rates, and then they can set up the entity. They can make sure they kind of help you along the way. They can help you with the funding rounds as well. So there's more of a package deal from the corporate side that we have at the firm, but from the IP side, there's really no package deal, because it's never a simple and repetitive process. It's usually different depending on your specific situation. All right. Any additional questions?
Yes, can you email the link to your office hours today? I don't see it in the email, and I would like to schedule something. I do have a few questions about my business in particular.
Yeah, of course. Happy to do that. What I'll do is I'll ask Todor to circulate my information to all the participants. I think he was recording the session, so what I'll do is I'll make sure he circulates the recorded session as well as the slides and my information there, so that anyone interested can actually just reach out. What I can do is, I will.
Can I schedule at 3 p.m.?
Yeah, no, it's fine. I'll reach your. All right, here we go. So I just shared my my email address in the chat. So if anyone's interested, Nicole, you can reach out and just let me know exactly what time works best for you. Just give me your number for that through email, and we can chat today. It's fine. But if
Okay.
anyone else is interested, they can reach out via email. It doesn't have to be today necessarily. I'm available anytime to chat. So if anyone does have any questions, they can reach out and we can discuss anything specific that you may have. All right. Well, yep, it seems like those are all the questions we had. So I appreciate everyone joining us. And again, if you have any questions, please shoot me an email. But otherwise, have a great day. Appreciate it.
Thank you, Vadim. And sorry, my connection disconnected.
No, it's fine. It's fine.
All right, I'll make sure to share the presentation with any of you who registered for the event. And thank you, Vadim, for working with all the companies at NextWeb and providing all this valuable support and information throughout the years. We really appreciate it. And I'm pretty sure the entrepreneurs in our network also appreciate it. Thank you, and looking forward to your next presentation and your office hours.
Perfect. Thank you, Todor. Appreciate it.
All right, see ya.
Have a good one, everyone. Bye.